Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Professor Kavita Solanki at University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Delhi, Dwarka. Today we are going to talk about Factory Act 1948, into which this is lecture number 6, Historical Development of Factory Act in India, applicability of the Factory Act, important provisions relating with the health, safety and the welfare of the workers, annual leave with the wages, the important definitions which has been given under this act. Historical development of factory legislations. So first establishment of the cotton mill was in 1851 and the establishment of jute mill in Bengal. At the time when this kind of the establishment was set up, we had not any uniformity into the works, into the number of the hours, and maximum it has been realized that the exploitation has been caused to the children and the women into the factory. Indian Factory Act 1881 was passed, and the purpose was just to give the protection to the women and to the children. After that, in 1819, the Royal Commission was set up, and the recommendations were given by the Royal Commission at that time to review the factory conditions, and just because of the only basis of the Royal Commission, the first Factory Act was passed in 1891. Factory Act 1891, it amended the definition of the factory. It includes the premises employing 50 or more persons. It empowered the local governments to extend the act to the premises employing 20 or more persons. It introduced the provisions for the women employees and the limited working hours. Mandatory 30 minutes of the rest has to be given it to all the employees. Subsequently, this act has been amended so many times and the revisions has been made. In 1911, this act was amended. In 1922, act amended into the implementation of the ILO conventions and that were dealing with the hours of the work. And 1934, act thoroughly revised and redrafted based on the recommendations of the Royal Commissions on Labour. Factory Act 1934, it has been mentioned that into the factory for the first time, that is, the power was used and where the more than 10 persons were employed, reducing the working hours, improving working conditions into the factory, adequate protection for the enforcement of this act. They were giving this number of the hours for the children had been reduced under this act. So the special measures has been taken under this act. Factory Act 1948, again, it was revised and extended the scope of the 1934 Act. Into this Act, Factory Act 1948, health, safety and the major provisions, welfare of the workers and overtime rate of the payment has to be given to the workers under the 1948 Act. So the purpose was just to ensure the safe and the healthy working conditions into the factory and focused on minimizing bodily strain and eliminating fear and the danger of the accidents for the workers. So periodically this act has been amended again in 1976. With the rise of the chemical factories, a significant number of the chemical factories were established and they were involving the hazardous and the toxic chemicals. So, an increased safety and the health concern in each factories. Bhopal Gas Disaster Act 1984. After happening, because that was the kind of the world's industrial disaster. So, after happened this Bhopal gas disaster case, so again the amendment was caused into the that was amended. The Factory Act again was amended and we were talking about the hazardous occupations. So for this thing we highlighted that is stricter safety regulations has to be followed for the disaster preparedness. So this Factory Act has been amended so many times, so first is object of the Factory Act 1948. That is because into this act health, safety and welfare of the workers. Aim is just to take care of the bodily strain, how we can give the comfort, how we can maintain the efficiency through the health of the workers. We were taking care of the long standing hours has to be avoided into the factory, due intervals has to be given. So because this is here under this act we were treating that is an employee is the asset for any of the establishment. So like we were not treating the employee as a liability. So all the provisions has been made under this act is just to take care how the efficiency of the workers can be maintained. So the structure of the factory act is total we are having the 11 chapters. They are comprising of 120 sections and we are having the three schedules. And this act was enacted on 23rd September 1948 and came into force on 1st of April 1949. So when we see the scope and the applicability of this act extends to the whole of India. It applies to all the factories, including the factories belonging to the state, belonging to the central government, belonging to the state governments, belonging to the local governments. So this act would be applicable, and unless until the government has excluded, this act would be applicable. So benefit of this act was available to the person, those who are employed into the factory, and they are covered within the definition within the term workers. So the workers would be those who come under the definition of the workers. They would be getting the benefit under the Factory Act. Either they are doing the work on contractual workers or the time rate workers. So all the persons those who are doing the work, they would be given the benefit. Factory, it means it refers to the manufacturing process. So like manufacturing process is very, very important and it has been defined into the factory. So first is we are starting with the definition of the important definition under this act. For this, the first definition is that is a definition of the factory. And when we talk about the factory, it has been defined in section 2M of the Factory Act, and it says the factory means any premises including the precincts thereof, whereon 10 or more workers are working or were working on any day of the preceding 12 months or in any part of which the manufacturing process is being carried on with the aid of the power or is ordinarily so carried on. So it has been mentioned that is the definition of the factory is it is very, very necessary. There must be the number of the worker is, say for example, if we are having the 10 or more workers and they are using the power, they are using the aids of the power, then in that case, they would be coming under the definition of the factory. But if we are having the 20 or more workers, then in that case, and they are not using any power, then in that case, they are doing the manual work. They would be giving the benefit under the definition of the factory. And for the factory, it is very, very necessary that the manufacturing process has to be there into the factory. So under this act is we are saying that is precincts has to be that is a premises and precincts. So these kind of the words premises means those who are doing the work into the premises means like they are doing the work into the open land or land with a building or this kind of the work they are doing the owner open land, then we can say they would be coming under the definition of the factory. Say for example, if the worker they are manufacturing the salt from the sea water and they are converting the sea water into this salt on an open land, that would be coming under the definition of the factory. On the other hand, that is precincts means that is any space which is closed by the walls. But for this, we can say that those who are doing the work into the closed walls, they would be coming under the definition of the factory. So now the second definition is manufacturing process. This definition is very, very important and it has been defined in section 2K of the Factory Act, whom we would be saying the manufacturing process. So for this list has been cited under this act is whom we would be saying the manufacturing process. Either the process is making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing or otherwise treating or adapting any article or the substance with a view to its use, sale, transport, delivery or disposal. So if we are having, the intent is either we would be using this item for use, sale, transport, delivery or disposal, then we can say this is the manufacturing process. Second is pumping oil, water, sewage or any other substance, generating, transforming or transmitting power, like we can say that would be the manufacturing process. Composing types of the printing by letters, so like we are having the photograph, we are having the similar process of the book binding, that would be coming under the definition of the manufacturing process. Constructing, reconstructing, refitting, finishing or breaking up ships or vessels, that would be coming under the definition of the manufacturing process. Preserving or storing any article in a cold storage, that is coming under the definition of the factory. Say for example, if sometime the question comes whether the BD making is a manufacturing process, yes, because the first item we have mentioned, that is a making. So either someone is making the BD, rolling the BD and making this article ready for the market, that is a manufacturing process. If we are converting the kind of the films into the other thing, that is the manufacturing process. If we are preparing the foodstuffs and the other eatable items into the restaurants and making this kind of the items ready for the market with the intention to earn money, so we are making this article ready for the sale, that would be coming under the definition of the manufacturing process. Factory Act is applicable upon the workers, whom we will say workers. So we are having the defined definition has been given. Worker means under the Factory Act is, that is the person who has been employed, who is employed either directly or through any agency, who is employed in any of the manufacturing process or in cleaning any part of the machinery or premises used for the manufacturing process, or in any kind of work which is incidental to or connected with the manufacturing process or subject of the manufacturing process. The person, sometime what happened, it directly involved into the manufacturing process, but sometimes the person is incidental, connected, sometimes the person is connected with the manufacturing process. So the person would be coming under the definition of the manufacturing, into the definition of the workers. So sometime whether the test is relationship of the master and servant. So sometime what happened, like but just to get the benefit, or if the person is not having any supervision by the employer and they are not having the control by the supervisor of the master or occupier or any other person, so like we can't say the person would be coming under the definition of the worker, because there is a control or the supervision of the employer or the occupier is must to get the coming under the definition of the workers. We are having multiple cases, but I am taking one case here, that is a Shankar Balaji Vaje versus State of Maharashtra, into which one of the employee who was engaged for the rolling BDs, and the hour of the work was fixed, but there was no obligation to attend these hours, and there was freedom has been given it to this person. He could go at any time, it could come at any time, and there was no fixed salary for the actual supervision on the work. So payment was made on the quantum of the work. So because the assignment was given and the quantum of the work has been assigned, but there was no fixed timings for coming into the any of the this factory premises. So the Supreme Court has held that into this case, the person is, they won't be coming under the definition of the workers, because there is no control and the supervision over this worker. After that, definition of the occupier, this is a very, very important definition, and it has been given in section 2 clause N, whom we would be saying the occupier. Occupier means the person who has ultimate control over the affairs of the factory, provided in case of the firm or the other association of the individuals, any one of the individual partners or the member thereof shall deem to be the occupier, and in case of the company, one of the directors shall deem to be the occupier. Occupier means the person who is having the control over the ultimate affairs of the factory. And sometimes what happen if we are having the firm, then in that case, because firm is an association of the individuals, so there one of the individual partner can be the occupier. If it is a case of the company, then if it is a case, then one of the director can be the occupier. Or if it is a case the factory owned or controlled by the central government or state governments or any local authority, the persons who are appointed to manage the affairs, then in that case the person either appointed by the central government, state governments or the local governments would be considered to be the occupier. Here, the general duties of the occupier has been given in Section 7A. Section 7A has been inserted by the Factories Amendment Act in 1987, and this new section lays down the general duties of the occupier, which are as follows. Plant maintenance, that is a safe and without risk to the health of the worker. This is the duty of the occupier to see to what extent the plant is safe for the workers, and there should not be any risk which is involving to the health of the workers. Safeguard health and the safety with the use, handling, storage and the transport of the articles and the substance. Provide information. That is, this is duty of the occupier is the occupier would be providing the information, would be giving the instructions, training and the supervisions to ensure health and the safety of all the workers, and monitoring of all of the work environment. This is the duty of the occupier. And we are having the Section 7B, into which general duties of the manufacturers, etc., as regards the articles and the substances used for the use into the factories. So here we are having the general duties of the manufacturers relating with the articles and the substance for its use into the factory. For the purpose of this, the Section 7B talks about, it includes the plant and the machinery, and it lays down general duties of the designers, manufacturers, importers or the suppliers. As regard the article and the substance used into the factory, it would be the duty of the designers to ensure that the articles designed would be safe and without risk to the health of the workers. It would also be the duty to carry out necessary tests and provide adequate information regarding the safety and the risk to the health. So, importers of the articles also will have to ensure that the articles imported conforms the standards set out into the country or the standard adopted outside the country. Sometimes what happens when we talk about, we use ISI, International Safety Standards Mark, or sometime either the designer is manufacturing the toys for the infants. So it is a duty of this person is he must have to take care the edges of the toys should not be very sharp. This is the duty of the designer or the manufacturers. Like these kind of the items, either we are using into the country or we are importing that item, so it has to be very, very safe. So this kind of the duty has been assigned. After that, other definition has been given. Say for example, adult. Adult is the person who has completed the age of 18 years. Adolescent means that is a person who has completed the age of 15 years of the age. But the person who has not completed the age of 18 years. Calendar means calendar year. All the time we are using the calendar. So calendar year means it includes the 12 months of a year. It beginning with the January and the last with the December. And child means a person who has not completed the 15 years of his age would be considered of the child. Young person means the person who has not completed the 18 years would be considered to be the young person. Day means 24 hours. Machinery means now, because whom we would be saying the machinery, it includes prime movers, transmission machinery and the appliances whereby the power is generated, transferred and the transmitted. Approval, licensing and the registration of the factory. This is because this is very important when we talk about approval and licensing and the registration of the factory. This is the duty of the occupier. He must have to see this kind of the factory has been, the layout plan has been approved by the government and the license has been issued and the registration of the factory has been done. So for this we are having the Section 6 where the state government empowered to frame the rules for the compliance, and into which we are having the Section 4. We can say that the state government may declare separate departments or the branches of a factory as an individual factory on which the written request by the occupier. And we are having the state government, they can exempt any of the factory from the provisions. Say for example, in case of the during public emergency or the otherwise we are having the time limit has been fixed for this. because if they want to start any kind of the factory, so for this the approval has to be taken up by the occupier, and this factory has to be registered and the licensed in accordance with the state government rules. Submission requirements, the plans and the specification for the approval by the chief inspector or the state governments. So it is very necessary. They want to execute it, they want to set up any kind of the factory, they must have to produce their blueprints. The plan and the specification that has to be approved by the chief inspector and the state governments. So previous permission required for the construction or the extension of the factory, because if the employer think yes they want to extend the factory, they can't do it. So for this they need a previous permission for the extension of the factory. And if they want to replacement or the addition of a machinery, does not count as an extension if it does not reduce the clear working space or harm environmental condition. Of course they can add on machinery if they are having the enough space and they think it won't be hazardous, it will not interfere with the working of the factory. They can add on the machines, and the full building plans and the specification must meet the rules compliance. So registration and the licensing require the payment of the prescribed fees has to be given by the occupier, or we can say the employer, and we are having that is a provision for the appeals. So permission for the site approval or the factory extension must be granted within 3 months. Sometime if we don't get any response, the permission is presumed. But if the refusal has been given for the permission, then they can go for the appeal within 30 days, and they can appeal to the state governments. If that has been this kind of the license has been refused by the chief inspector, and they can appeal to the central government if refused by the state government. So into which the notice is very much required, but notice is mandatory for the licensing. This is a duty of the occupier. They must have to provide at least 15 days notice before using any premises as a factory. They cannot start the work into that premises. So they want to use any kind of the precincts or any premises, then for this they must have to take the proper approval, and for this the time limit has been given. The minimum 15 days time the approval they must have to give. They must have to take this kind of approval at least 15 days before starting any of the use of the factory. And into this factory notice they must have to include the name and the location of the factory, name and the address of the occupier, name and the address of the premises owner, nature of the manufacturing process, total rated horsepower. It means they are talking about how much volt, how much the power is required. They must have to tell how much is the standby power they are having. This occupier is having the name of the manager of the factory, number of the workers likely to be employed, average number of the workers employed in the last 12 months. So, and other particulars which has been prescribed by the rules. So, additional requirements. So, these factories, if the factory is already working, then in that case, before the commencement of this act, they must have to notify the chief inspector. So, they must have to take care of all these things. If the someone is not making the compliance, then in that case with section 6 and 7 it constitutes an offence which is punishable under this act. Chapter 2 is talking about the inspecting staff. So we are having the inspectors, section 8 and 9. Now we are using the term inspector as an inspector come facilitator, but under this we are having this inspector. So they would be appointed by the state government, and they can appoint inspector by notification. So we are having the different types of the inspecting officer. Say we are having the chief inspector, we are having the additional chief inspector, joint chief inspector, deputy chief inspectors, inspectors, additional inspectors. So they would be appointed by the state government, so they can exercise the powers. And we are having like these persons, they can be they can be disqualified if the someone is directly hold the office, directly or indirectly, having the interest into the factory, its process, business or patents or machinery. Then in that case the person can be these authority, they can be disqualified. And after that we are having the definition of the public servants. All the inspectors and appointed under the Indian Penal Code, they would be coming under the definition of the public inspector. Now they come under the Bharatiya Nyaya Sanhita 2023. So they would be coming under the definition of the public servant. So after that We are having the system for these certifying surgeons in section 10, because these certifying surgeons would be appointed by the state government and they would be qualified medical practitioners. So the duty of these certifying surgeons, they are assigned specific local limits or designated factories. So state governments, they can approve and they can delegate power to these qualified medical practitioners for a specified period, and again they can be this certifying surgeon can be disqualified and cannot be appointed or continue to hold the position if they are become the occupier of a factory or have a direct or the indirect interest into the factory. It's a process, business, patent, machinery, or otherwise employed by the factory. But a state government is having the right, they can give the exemption through a written order and subject to the specified conditions. So where they can exempt any of the person or the persons. Chapter 3, health. Again this chapter is very important, and the provisions has been given regarding the health of the workers. The health of the workers is first is that is the cleanliness, because the cleanliness, every factory must be kept clean and free from effluvia, and so this is the duty of the occupier, is they must have to keep the factory very clean. And if there is any kind of the harmful discharge through the manufacturing process is there, so if they are having effluvia is there, so like they must have to take care of it and they must have to take the measures, so just to keep the factory clean. So what they can do is they can like for this, the daily removal of the dirt has to be there, and the dirt or the refuse. So for example, if they are doing any kind of the work from this manufacturing act, they are discharging the refuses or dirt, they are producing the dirt, then in that case this kind of the dirt or the refuse has to be removed on a daily basis. Floors and the benches of the workroom has to be cleaned. Staircases and the passages has to be cleaned, and on a weekly basis we can see the cleaning of the floors, and for which they would be using the they can wash with the disinfectant, or they can use the other effective methods. Or if the sometime what happen, if the floors get wet during the manufacturing process, then in that case effective drainage must be provided and maintained. So this is the duty of the occupier to take care of all these things. Sometime what happen, the internal maintenance of the wall is mandatory, and because they have to maintain the walls or the ceilings, or if they are having the partitions or the staircases. So for this what they can do is, if it is a non-washable kind of thing, they can repaint, they can revarnish, so because the things would be looking very clean and shiny. And but the provision is they have to do it, this practice they must have to repaint or revarnish once in every 5 years. Washable water paints, then in that case they can repaint once every 3 years, and they can wash once in every 6 months. They have to take care of the impervious surfaces, and for the whitewash and the color wash at least once in every 14 months. Doors, windows, frames, wooden or metallic structures, they have to be painted or varnished at least once in every 5 years. And for this they must have to maintain the record, because sometimes what happens, sometimes the inspector come for the visit. So for this, for the safe side, the procedure has been prescribed by the government. They must have to maintain the record, and they must have to make the dates of the cleaning, painting, and entered into the prescribed register. And but the state government can give the exemption. Sometime if full compliance is not possible, state may exempt the factory or part or class of the factories, and sometimes specify the alternative methods even for the cleanliness. And after that, disposal of waste and the effluents, like if they are discharging any kind of the liquid waste, the government they can provide any kind of the effective arrangements for the treatment of the waste and the effluents. So just to avoid the make it harmless, and safe disposal of the treated materials. And for this, what the state government can do is they can prescribe the arrangements and require approval for such arrangements. So they must have to they can prescribe this kind of the methods. And after that we are having the system for the ventilation and the temperature. So every workroom must ensure adequate ventilation, that has to be circulated by the fresh air, comfortable and the safe, temperature has to be there. It means like that temperature has to be very safe, and into such a condition it should not injure the health of the workers, it should not make any injury to the workers. Sometimes what happens, the specific requirements has been given, like walls and the roofs must be designed to keep the temperature as low as practicable. Sometimes they are doing the work into the factory, the work is of such a nature, they are producing the heat, say they are doing the welding work, then in that case the methods can be, specific requirements can be given. And this is the duty of the person is just to protect the workers is like effective means can be prescribed by the government, and state government they may prescribe the standards of the ventilation and the temperatures, and they can require the installation of the measuring instruments, for which sometime if we are having the cooling plant or the AC into the building, so normally we have realized the person they come to take the readings, they can go for the installation of the measuring instruments, and for this they take the note of it, maintenance of the record has to be there. And we are having the chief inspector for this, and the chief inspector may issue the written orders for the corrective measures if the temperatures are excessive. So this is duty of the occupier or the employer to take care of these kind of the measures. And after that, dust and the fumes. So in every factory which is with the harmful dust and the fumes or the impurities, this is a duty of the occupier, and they must have to use the effective measures, like just to prevent the inhalation or the accumulation. So for this what they can do is they can use the exhaust appliances near the point of the origin. So sometimes what happen, they prescribe sometime like kind of the example is a dust proof husk chamber, so they are provided. We are having the different means, so exhaust appliances has to be there, and at the point of the origin they must have to enclose the origin point as much as is possible, and otherwise what will happen, it can be offense. So if they have given the warning, so the time period has been given, so this is the duty of the occupier, they must have to install these exhaust appliances. If they are not doing, and by chance because the person can be prosecuted, so that normally they give the 3 months of time, but if this inspector is coming for the second visit and nothing has been done, then in that case the person can be booked and the legal proceedings can be taken against that person. So after that we are having the artificial humidification. So this is the duty because artificial humidification is normally state government, they prescribe the standards of the humidification, and they regulate the methods, and they require the test and the records of the humidity, to what extent and how to conduct the test. So normally they are notified by the state governments, and they prescribe the method for the adequate ventilation and the cooling. So water can be used for this purpose, and the water can be it has to be the drinking water, and effectively it has to be purified before use. So if the water is for the artificial humidification is not purified, then in that case the inspector may issue an order and directive the corrective actions with a specified deadline. And the problem is into the factories, that is a overcrowding. So it is the duty of the occupier is no workroom shall be overcrowded to the detriment of the workers' health, because for this a minimum space per worker has to be provided. Say for example, if the factory has been set up before the passing of this Factory Act 1948, then at the time before the commencement of this, so 9.9 cubic meter was provided per person, but if the factory built after the passing of this act, 14.2 cubic meter has been provided, so they have to make the compliance of it. So we are having the chief inspector, and he can order posting of the notices showing the maximum number of the workers allowed per room. Normally we do it, these kind of the practices at the time of the examination. We fix a number of the student has to be in a one room. It's like this kind of this thing. So they will fix to what extent the number of the workers can be in a one room. So but inspector can give the grant the exemption from this thing. and but subject to the condition. But this kind of the order has to be into the writing. After that, section 17 is very, very important for the health of the worker, is that is the lighting. So every part of the factory must have sufficient and the suitable lightings. Either it can be the natural lighting, or it can be the artificial lighting, and so they must have to take care. So, and this thing should not to be obstructed, and effective provisions has to be there. So like the lighting has to be, should not to be like that, like the shadow causing a strain or the risk of the accidents. So for this, the state government, they can prescribe the lighting standards for the factory, and the specific process can be prescribed by the government. After that, drinking water facility. So section 18 deals with the every factory must provide effective arrangements for the sufficient supply of the wholesome drinking water. So for this, water point must be conveniently located for all the workers, and this kind of the drinking water points must have to be legibly marked. So they must have to marked that is a drinking water. So, and has to be into such a, they must have to use the language so by which the majority of the worker they can understand. So, and but like they should not to be, these drinking water should not to be located within 6 meters of washing places. Either they are washing their clothes, or the urinals, or the latrines, or spittoons, open drains, or any other sources of the contamination. So unless until these things has been exempted by the chief inspector, and especially into the writing. So, and for the factory with more than the 250 workers, they can have the facility of the cool drinking water during the hot weather, and they ensure the effective distribution of the waters. So the state government, they can frame the rules for the enforcement, and for this, like the inspection can be made, and so they must have to take this thing. After that, we are having the system of the latrines and the urinals. So into every factory, sufficient latrines and the urinals accommodation of the prescribed type, this has to be prescribed by the government, conveniently located and accessible to all the times. So because latrines should not to be at such a far place, or the urinals, I mean, it would not be possible to access. So it has to be conveniently located, and it has to be accessible for all the times. So separate enclosed facilities, and it has to be separate for the male and the female workers. So, and this kind of the latrines and the urinals have to be adequately lighted and ventilated, must not open directly into the workrooms, and all the facilities must be kept clean and sanitary with all the times. And for this, they can employ the sweepers. So, and the job would be of the sweeper would be cleaning latrines, urinals, and the washing places. Into the factories, we are having the more than 250 workers. So facilities must be of a prescribed types, and according to the act, and the floors and the internal walls, like say up to 90 centimeter, must be finished with the glazed tiles or smooth or the polished. So, and the regular cleaning has to be there. Floors, walls, and the blocks and the sanitary like pans has to be cleaned at least once in every 7 days. They should use the detergent and the disinfectants. So state government, what they can do is they can prescribe the number of the latrines and the urinals based on a number of the male and the female workers. So that has to be, and may provide the additional sanitation rule, including the workers' obligation, measures ensure workers' health and the hygiene. Say, for example, when we see at the time of the COVID, so at the time they were doing, they were using the mask, and they were using the disinfectants, and they were using the sanitizers. So additional rule can be provided by the government. And after that, we are having the system of the spittoons. So in section 20, every factory must provide a sufficient number of the spittoons placed at the convenient locations, and it has to be maintained in a clean and the hygienic condition. The reason is because normally what happened the workers, they use the tobacco and the other kind of things, gutka. So for this, they cannot spit on any place. So for this, we are having the system of the spittoons has been provided, so they cannot spit everywhere. So And for this, the state government, they may prescribe and type and the placement of the spittoons, and they have to be clean, and the proper maintenance has to be there. If the someone is not making the compliance, then the penalty can be imposed. But unfortunately, the penalty is of 5 rupees only. So after that, we are having the system. We are having the provisions for the safety. So chapter 4 talks about the safety provisions. So here, this is the occupier responsibility, and when we talk about this kind of the responsibility towards the workers, so these provisions, they are basically the safety provisions. They are absolute in nature, and they have to take a best measures just to take care of the safety of the workers. So this is the say for example, sometime what happened, the fencing of machinery we are having in section 21. So this a compulsory fencing has to be there. If this kind of the machinery is very dangerous, and the part of the machinery like has to be fenced properly, so then in that case the liability is absolute in nature, and the employer cannot evade, he cannot escape from his liability, like I cannot afford, this is very expensive, so I can't hire, I can't manage. So the state government, they can provide the further precautions, and also provide the exemption even to a particular factory. So dangerous part of any of the factory means machinery from which the danger may occur. So like when the danger may occur is like say for example, during the working of the machine, sometime it can be the negligence, sometime if they have hired the third person or the outsource, but it is the responsibility of the occupier. And after that, we are having the work on a near machine or in motion. So those who are doing the work that has to be work on or near machine in motion is, so normally these person, they have to be trained male workers, they have to be adult, they can wear the tight fitting clothes, so women will not be allowed. Women or the young person shall not be allowed to clean, lubricate or adjust any part of the prime mover. And those who are doing the work near this machinery in motion, so their name has to be registered into the register. So and employment of young person on dangerous machines, so normally they prohibit. And after that, the special instruction has to be given, and the precautions has to be made. So if he has received, this young person has received a special training in work, then he can work if he is having the adequate supervision. The person who is trained into this line, striking gear and the devices of cutting of power. So sometime because this system has to be there, if they want to strike down, they want to cut off power, so this kind of the provisions has to be there. And we are having the sometimes self-acting machines. This is the duty for the self-acting machines. So further safeguards has to be provided. So there should be the officer in charge, and they must have to take care of this thing. Like if they are having the self-acting machines, so distance of 45 centimeters has to be there from the fixed structures, and which is not a part of the machine. So sometimes the cursing of the machine, so because this is the mandatory provisions, so they must have to guard all the set screw, bolt and the keys, resolving parts, and they must have to encase tooth, frictions, gearing. So and if they are giving, this is because they have to take care, no one is allowed to sell or the hire of the unsafe machinery, otherwise the person can be accountable up to, and the person can be imprisoned even for this, and the fine can be imposed. So and the state government is the authority who can create a rules for the safeguarding of the dangerous machine. And prohibition of the employment of women and the children near cotton openers. So normally it is not allowed, it prohibits women and the children, but and especially for the pressing of the cottons where the cotton opener is set. But if the end of the cotton opener that is in a separate room, and then in that case they can be employed. Hoist and the lifts, so they should be in a very good condition, sound construction has to be there, good material has to be used, and they have to be thoroughly examined. Resolving machines, we are having the pitch sums and these things. We are having the precautions against the dangerous fumes. So because this is very important, and the explosives or the inflammable materials, we are having the different provisions for this. In case of the precaution, in case of the fire, so this is the duty of the occupier. They must have to take this kind of the note. Safety for the building and the machinery and maintenance of the building, this is their duty. And we are having the system for the safety officers. And now chapter 4a, it relates with the provisions relating to the hazardous process. So for this, this thing has been amended after the Bhopal gas disaster case in 1987, and where we have defined the hazardous process has been defined and the duty has been imposed if the someone is dealing with the hazardous process. And for this, special care has to be taken care, and like if it is a case of the waste or the effluents that can harm the public, so for this the utmost duty has been that is caused upon the occupier, and the state government may by notification in official gazette they can amend the first schedule by way of the addition, omission and the variation into of any of the industries specified into that schedule. So for this we are having the provisions which deals with the hazardous process. So section 41A to 41H, because the definition of the hazardous process has been given, say any process involving dangerous chemical, gas or the substances posing health and the safety risk to the workers or the environment, then in that case we would be saying this is a hazardous process. So for this we are having the constitution of the site appraisal committee has been constituted in section 41B. So after the Bhopal gas disaster case, so for this we have taken the persons into this committee for the site appraisal committee from all the sectors. Either we are talking about the water act, we are talking about the environmental act and the different this thing, so to evaluate the new factories, and so the safety standards has been provided, and after that the grant can be given. Compulsory disclosure of the information, this is the duty of the occupier. They must have to disclose the information regarding the hazardous process, including health hazard, emergency plan, safety measures to the workers or the relevant authority. So this is the, and specific responsibility has been cast to the occupier, that is occupier must maintain safety standards, conduct periodical health checkup of the workers and provide necessary safety training to the workers. And we are having the workers participation in safety management. Yes, workers would be participating, and the committee includes representative from workers in the management. A right of the workers to warn about the imminent danger. So workers can report imminent danger to their supervisors or the inspectors without fear of the retaliation, and the emergency standard has to be provided. So central government may prescribe the emergency standards for the hazardous process if required, and permissible limit of exposures. So limit has been fixed, that is exposure to the hazardous substances has been this is for the safety of the workers, so standard has been fixed. In chapter 5 we are having the welfare provisions. So welfare provisions, so they are letting with the washing facilities has to be provided to the workers, so they can go for the suitable washing, and both will be entitled, male and the female workers, and that has to be conveniently accessible. Facility for the storing and the drying cloth has to be given. Facility for sitting has to be provided, so they should not stand for the long time, so at least they can take a rest. And first aid appliances has to be given, so in case of first aid box has to be there into this factory, and the ambulance room has to be provided where the number of the workers are 115 numbers, and the canteen facility has to be given, so where the workers are 250 or more workers, they must have to provide the canteens, and the rules relating to the food and the hygiene and the pricing has to be indicated. Shelter, restroom and the lunch rooms has to be given. If they are having the 150 or more workers, they must have to provide the shelter, restroom and lunch rooms for the workers, so they can sit and rest during the breaks. And the crutch facility has to be provided. So crutch facility, factories employing 30 or more women workers, they must have to provide the crutch facilities for the children under the age of the 6, and the standards has to be provided, and the staff who is taking care of this thing has to be trained. So we are having the number of the workers, they are 500 or more, they can appoint the welfare officers, so who can oversee the welfare of the workers, and they can make the compliance. And the state government is having the authority who can go for the the additional welfare measures. So section 55 to 66, chapter 6, it talks about the working hours of the adult into the factory, and they deals with the maximum working hours, daily hours, and the intervals for the rest, prohibition of the double employment, and they are talking about the night shifts, overtime wages, daily working hours. So for the adult should not to be more than 9 hours. So weekly working hours, no, so that should not to be more than 48 hours in a week. And when we are talking about the rest intervals, so half an hour interval has to be provided, so maximum of the 4 hours of the continuous work. So and they should not exceed the, if we are talking about total working hours, though, like including the rest intervals, should not exceed more than 10.5 hours in a day. When we are talking about night shifts, the provision has to be made in that way. The female should not to be allowed for the night shifts, and weekly holidays has to be declared, like Sunday normally we declare. The overtime work, so permissible if the total hours including the overtime do not exceed 60 hours a week or 12 hours in a day. That is, and but it is the duty of the occupier, they must have to make the double rate of the wages for the overtime work. Restriction for the female workers, so they are restricted from the working between the 7 p.m. to 6 a.m. and except with the prior approval, the subject to the safeguards for their safety. Now this thing has been diluted, and after that we are having the employment of young persons. But into this section 67 to 77 talks about the employment of young persons. But in section 67, prohibition of the children below the age of the 14 years in factory, they are prohibited. And 68 to 70 talks about the working hours of the certification for the adults, night shifts for the young persons. But it is a duty of the occupier, they must have to maintain the record, otherwise the penalties can be imposed. Section next, chapter 8 is talking about the annual leave with the wages. So it has been defined in section 78 to 84. So because after that, and we are having the special provisions has been given in chapter 9. They are incorporated in section 85 to 91, and we are having the into chapter 10, we are having the penalty and the procedure. So here they deals with the from section 92 to 106, and chapter 11 deals with the supplemental provisions, where it starts from section 107 to 120. And here like we are having the system where we are talking about the appeals can be made, workers' right, and the exemption can be given, and the authorities has been given when we are talking about the supplement. I think it will benefit you and it will helpful for you. So this is from my side. Thank you so much.
Hello and welcome to this piece of literary snippet. British humour doesn't have a very high standing in the world. When people talk about it, they usually do so with a certain degree of disparagement. Yet all this is, I think, rather unfortunate, because if I read out to you a certain section from Jerome K. Jerome's famous novel Three Men in a Boat, you will realize that not only is British humour genuinely funny, it is probably even better than some of the other samples of humorous writings that you might have read in the recent past. The story that I'm going to read out is told by Jerome, who thinks he is suffering from some kind of a malady. I remember going to the British Museum one day to read up the treatment for some slight ailment of which I had a touch. Hay fever, I fancy it was. I got down the book and read all I came to read, and then, in an unthinking moment, I idly turned the leaves and began to indolently study diseases generally. I forgot which was the first distemper I plunged into. Some fearful, devastating scourge, I know. And before I had glanced half down the list of premonitory symptoms, it was borne in upon me that I had fairly got it. I sat for a while, frozen with horror, and then in the listlessness of despair, I again turned over the pages. I came to typhoid fever, read the symptoms, discovered that I had typhoid fever. Must have had it for months without knowing it. Wondered what else I had got. Turned up St. Vitus's dance. Found, as I expected, that I had that too. Began to get interested in my case and determined to sift it to the bottom, and so started alphabetically. Read up ague and learnt that I was sickening from it, and that the acute stage would commence in about another fortnight. Bright's disease, I was relieved to find I had only in a modified form. And so far as that was concerned, I might live for years. Cholera I had with severe complications, and diphtheria I seem to have been born with. I plodded conscientiously through the 26 letters, and the only malady I could conclude I had not got was housemaid's knee. I felt rather hurt about this at first. It seemed somehow to be a sort of slight. Why hadn't I got housemaid's knee? Why this invidious reservation? After a while, however, less grasping feelings prevailed. I reflected that I had every other known malady in the pharmacology, and I grew less selfish and determined to do without housemaid's knee. Gout, in its most malignant stage, it would appear, had seized me without my being aware of it. And zymosis. I had zymosis evidently from boyhood. There were no more diseases after zymosis, so I concluded there was nothing else the matter with me. I sat and pondered. I thought, what an interesting case I must be from a medical point of view. What an acquisition I should be to a class. Students would have no need to walk the hospitals if they had me. I was a hospital in myself. All they need to do would be to walk round me and after that take the diploma. Then I wondered how long I had to live. I tried to examine myself. I felt my pulse. I could not at first feel any pulse at all. Then all of a sudden it seemed to start off. I pulled out my watch and timed it. I made it 147 to a minute. I tried to feel my heart. I could not feel my heart. It had been beating, but now it had stopped beating. I have since been induced to come to the opinion that it must have been there all the time and must have been beating, but I cannot account for it. I patted myself all over my front, from what I call my waist up to my head, and I went a bit round each side and a little way up the back. But I could not feel or hear anything. I tried to look at my tongue. I stuck it out as far as ever it would go, and I shut one eye and tried to examine it with the other. I could only see the tip, and the only thing that I could gain from that was to feel more certain than before that I had scarlet fever. I had walked into the reading room a happy, healthy man. I crawled out a decrepit wreck. Our friend next visited a doctor, and there he got a prescription which said to eat well, to go for long walks, and not to worry his heads over things he didn't understand. See you in the next episode of Literary Snippets.